Should we start now, Chang?
Yes, I think it's time now. And
Right.
because today is the last topic of our webinar series, so in the beginning, I would like to introduce our Mr. Nguyễn Mạnh Dũng to have an introductions about the topics as well as introduction about our speakers, the panelists today.
Thank you, Chang. Good afternoon, good morning, good evening, everyone. My name is Nguyễn Mạnh Dũng. I'm the founder and senior partner of Dũng ST Associate LLC, and I would like to welcome everyone to the 7th webinar and also the last webinar of our 2021 arbitration series. The topic that we would discuss today is protecting your investment when a contractual dispute could not be called off. Throughout the 6 previous webinars, we have had the chance to discuss many important aspects of the international commercial arbitration so that disputes can be resolved in a fair, quick, and cost-effective manner. However, even if with all the tips and methods discussed, the dispute can still not be resolved satisfactorily to the party and even come to what we call the investor test dispute. As reported by the United Nations Conference on Trade and Development, UNCTAD, in September 2021, the total ISDS case count has reached over 1,100 by the end of 2020. And to date, 124 countries and 1 economic grouping are known to have been respondent to one or more ISDS claims. This is particularly relevant in the Vietnam practice, where many large deals and disputes arise from the project with the involvement of the state authority and state-owned enterprise. In addition, here, Vietnam has entered into many international investment treaties, providing for investor-state arbitration mechanism. Therefore, we would like to take this chance today to discuss the most notable issues surrounding ISDS, partial investor-state arbitration. Presenting today, I'm deeply honored to introduce Professor LOUKAS MISTELIS, Professor of International Law and Arbitration, Director of Institute of International Commercial Law, former Director of School of International Arbitration 2002 and 2019 at the Queen Mary University of London, and founding partner of MISTELIS and Hardin, an arbitration law consultancy. He is an experienced arbitration academic and practitioner, having acted for more than 20 years. He is also acknowledged authority on international dispute resolution and investment treaty law with more than 60 referred articles and 13 books. He is also a member of the exit panel of arbitrator for the term of 2014-2020. He research focused on international dispute resolution arbitration, international commercial transaction, verification of private law, commercial and civil law reform in Central and Eastern Europe and Asia, energy, natural resources, and BIT. His substantial arbitration experience includes more than 70 arbitration and cover ad hoc and ICC, exit, and CIA, unseasoned SCC, Swiss Chamber, and Moscow cases. And I must say that he was my teacher as NIM program 2007-2008. He's also directly supervised my NIM thesis on the operation of arbitration institution in the Asia Pacific region. I have actually used his lesson during the process of the drafting the law of commercial arbitration 2010 and the first legislation on the commercial mediation in Vietnam, Decree 22, as you all aware. So his lesson has very strong impact on our legal profession today. The second distinguished speaker is Mr. DOMINIC. He's a partner of Quinn Emanuel, the largest firm in the world devoted solely to business litigation and arbitration, with approximately 800 attorneys throughout 23 offices around the world. DOMINIC specializes in international arbitration, international litigation, and public international law dispute. He also sits as an arbitrator, has acted as counsel under the auspices of many of the main arbitration institutions, including ICC, NCAA, FCC, SIC, JCAA, CITAC, SONS, ad hoc, and unseasoned reference, Since 2005, DOMINIC has been ranked by Asia Pacific Legal Finance as a leading independent in dispute resolution and has been specifically recognized by Chamber Global since 2007 as a leading independent in public international law, international arbitration, and international dispute. From our firm, we have Mr. Nguyễn Ngọc Minh, the head of our arbitration practice in Dung ST Associates. Besides practicing as a leading counsel representing local and international clients in international arbitration conduct under the ICC, SIC, FCIArb, and VIC rule. Minh has also recently been appointed as arbitrator, I think maybe one of the youngest arbitrator on the case of both VIC and SIC of Singapore. And finally, the moderator of today's webinar, Ms. Nguyễn Thu Trang, an arbitration partner at Dung ST Associates, who focus on commercial and investment arbitration, commercial and enforcement litigation, and international business law. Chang has extensive experience in many arbitration arising from the construction and infrastructure project, energy sector, retailer, and international trade conducted at ICC, SIC, FCIArb, and VIC. Without waiting any longer, I will give the floor to the moderator and the speaker. Thank you.
Yeah, thank you very much, Mr. Dung, for your introduction. And to begin, we would like to invite Professor MISTELIS to deliver a keynote speech on our topic today, which is when a contractual dispute could not be cooled off. In his speech, we will understand when and how contractual claims be converted into investment claims and how the host states will prevent such circumstances. Professor MISTELIS, the floor is yours, please.
Thank you very much, and thank you very much for the invitation to address the audience of this webinar. I'm delighted to be amongst friends and some former students. And of course, it would have been nicer to be able to have that seminar in Vietnam, but the current circumstances make the online perhaps the only option, and at the same time a bit more accessible for other people who may not have been able to travel. So the topic I wanted to address is effectively how you protect your investment and at what stage a contractual dispute may be transformed to an investment dispute. And given that this topic is really at the forefront of any in-house counsel and sometimes also outside counsel that is countering a potential claim, and also it is also critical for governments to be thinking about what may be done to avoid disputes where disputes can be avoided. I decided that I'm going to address the topic in 4 parts. In the first part, I will be referring specifically to the question of this, how contractual disputes may be transformed to investment disputes. And investment disputes typically entail the breach of a treaty provision, a breach of international law, because ultimately ISDS cases, investor state dispute settlement cases, deal with public international law liability of the state. In that respect, of course, and untangling the title, I will also be spending a bit of time referring to cooling off periods, umbrella clauses, and then in order to give a much more complete presentation, I will be looking at state actions and what states can do to avoid disputes, to prevent disputes. So starting then from the top, how and when can contractual claims be converted to investment claims? And there's no doubt that the majority of claims around the world are contractual claims, not investment claims. ICSID has a very good year again this year, and in the first 10 months of the year, there are only about 50 cases that can be registered with ICSID, while the same number, if one looks at the major commercial arbitration institutes, will be running into the thousands. But when there's a contractual claim that a foreign investor brings in front of before a national court, And after the local remedies have been exhausted, there might be circumstances when then there will be a trigger for an investment claim. That trigger will normally necessitate that either there has been a complete lack of judicial protection or inadequate judicial protection, or indeed denial of justice. The foreign investor pursuing a contractual claim is not given an adequate remedy in the host state. We have also sort of derivative, if you wish, contractual claims which become investment claims, and that is when out of a contractual dispute, a commercial dispute, one obtains an award in commercial arbitration, let's say from the ICC, the Singapore International Arbitration Center, and tries to enforce this award, but this award cannot be enforced domestically for reasons which are not necessarily transparent, and perhaps also not based on the New York Convention on the Commission Enforcement of Awards. The other option, of course, is to have a specific agreement for ISDS in a traditional commercial contract. There we have a much broader literature, and I'm not going to address all issues, but knowing, for example, that Vietnam has a legacy which goes back to French law, and French law is very familiar with the concept of the, I'm saying the legacy, not necessarily the current law in Vietnam, has a legacy of this administrative contracts which made with a state entity, a state-owned enterprise. Some of these cases, or long-term energy extracting industries contracts, would contain often an ISDS clause, which would give an opportunity to a foreign party to bring an arbitration claim against a state. That would not be typically an exit claim, but it would be an ancestral. In some cases, could be even ICC or Stockholm Chamber of Commerce. But such clauses are not unusual, and actually they become quite trendy again now that the traditional ISDS system under exit is being under some sort of a criticism. Last but not least, is again another treaty mechanism in which you can bring a contractual claim into an investment environment that doesn't convert a contractual claim to an investment claim, but an umbrella clause jurisdictionally would allow you to bring a contractual claim within an investment arbitration forum. Let's sort of untangle a few of these topics a bit further. In order to have a contractual claim being converted or brought into the context of an investment claim, it is important that there is a bilateral or multilateral investment treaty in the background, or indeed a domestic law for the protection of foreign investment, which contains a relatively broad, or indeed very broad definition of investment. And for example, one of the key requirements that will be here is that the particular claim arises out of a long-term contract. Anything which has no particular duration, and we've seen many claims brought against Egypt, for example, that have failed, is because they are based on a transaction which is a one-off, irrespective of the value of the transaction. And it doesn't matter whether this is a supply of defense equipment, whether it's a supply of other services or goods to the state. If that's a one-off sales contract, that would not qualify under any circumstances as an investment dispute. And the operating definition we have is that this broad investment definition will require something of a certain duration. It will require a level of commitment on behalf of the state, and it will require an element of risk in the whole process. There's also the question as to whether this particular commercial contract has a significance in the development of the whole state. So some of these cases where a contractual claim was to be converted successfully or unsuccessfully into an investment dispute, I'm going to just briefly mention 3 examples. One is the example of Sullivan and the United States of America. Sullivan is planning a broader franchise in the southern states of the United States, in other words, franchises for funeral director homes. This somehow did not go ahead, and the potential franchisees, those who were engaging with Sullivan in order to become his franchisees, brought a claim in the courts of Mississippi. And in a jury trial, they were awarding not just damages, but also they awarded punitive damages. Sullivan wanted to appeal that decision to the Court of Appeal, but the rules of procedure required that Sullivan has to lodge a substantial amount of money, which is the amount of money that was awarded at the first instance, plus 20%, as a bond before he could raise the appeal. And of course, that amount of money was amounting to something in the region of $620 million US. And Sullivan says that means technically I have no standing. I cannot bring that money just to appeal the first court decision. And he fought the matter very, very much. This case under NAFTA never went to the merits because the United States successfully defeated jurisdiction and various other claims that technical claims that Sullivan has brought. So we have never seen what a tribunal would have said, but it's perhaps useful to say that very often people refer to the Sullivan case as the notorious Sullivan case. And Jan Paulsen has written a book called Denial of Justice, where a substantial part of the book criticizes law. In fact, almost half of the book is a critique of law. But there are two cases which are in Asia. One is a case called Saipem in Bangladesh, where Saipem has obtained, Saipem, an Italian construction company, has obtained an ICC award in normal ICC proceedings and has been trying to enforce this award in Bangladesh. And there were a lot of obstacles being put in the domestic context in Bangladesh for the enforcement of the award. And then eventually on that basis, Saipem brought an investment claim on the Italian Bangladesh BAT, and the tribunal assumed jurisdiction, but thought that the treatment that Saipem has endured in the courts of Bangladesh would be a breach of the treaty and would qualify effectively a derivative investment claim arising out of a contractual claim which has been adjudicated in arbitration. And the final case is a case of white industries and India. Again, a matter for the enforcement of an award, of a commercial award, where for at least 6 years nothing has happened at all in the Indian courts. And again, on the basis of fair and equitable treatment, white industries has substantiated an investment claim. However, most of the cases would be falling under the umbrella clause scenario, and I will come back to that very, very shortly. I would also like to bring an extract from a survey that Quinn has conducted in 2019-2020, together with the Corporate Council International Arbitration Group, which is an association of in-house counsel of major companies. And what is very interesting in that case is just, I'm going to present to you one single slide. You will see that corporations, and that is a response of in-house lawyers only, not arbitrators or arbitration lawyers. But you will see here that generally speaking, in-house lawyers prefer to have a contract-based arbitration. So a commercial type arbitration rather than an ISDS claim. And 81% have a positive view of that, while 8% will have a negative view. If you look at the treaty-based arbitration, a BIT, you will see here that 20% has a negative view and only 73% has a positive view. And then, of course, the most critique relates to litigation in the host state courts, where the negative view is 61% and the positive view is only 21%. So that is a very, very clear evidence that given the whole sort of debate about the legitimacy of ISDS, whether it should be survived as it is or would be amended, corporations respond very loud and clearly that they prefer contract-based arbitration, and that perhaps comes very much also to the face of the Court of Justice of the European Union, which said recently that European states cannot make contract-based arbitration, or they could have used investment arbitration because investment arbitration rather have been preferred. So, moving then to the second sort of theme that I would like to approach. I mean, one key feature of investment disputes is that we never just go straight to the arbitration, but there's a phase which is called a cooling off phase. And of course, that's not the tip of the iceberg, but it is where things are. And this cooling off period is supposed to assist parties to explore ways of resolving disputes. So a cooling off period is typically a provision in the treaty, often in the dispute resolution part of the treaty. And it is either for a period of 3 months, sometimes of 6 months. And during this period, and provided that the investor has given notice of the dispute, there's an opportunity to explore settlement of the matter. So it has often been debated, but I think there's clarity these days that a cooling off period does not affect the jurisdiction of the tribunal, but it affects the admissibility of the claims. And given, of course, that from the time of a filing of a case until we can get to a meaningful discussion, that period can be overlapping, and that's why it's almost never addressed as a jurisdictional issue. So during the cooling off period, there is a genuine opportunity to appreciate each other's case. Of course, parties, both the state and the investor, keep their cards very close to their chest, so they do not disclose unnecessary elements. And sometimes a trigger letter, a notice of dispute is as short as 4 or 6 pages. I have invested in that sector in your country. We have this, there's this PIT or this multilateral treaty. These things happen, and I intend to bring a claim, and I think I have a claim for this amount of damages. However, that given that the data that is being exchanged at the moment is very little, very few states engage fully in that cooling off period with a way of trying to resolve the matter. And it's not uncommon that the states will reply 1 day before the expiry of the deadline. So on day 89 or day sort of whatever that would be. So what we see very often is that cooling off period is an opportunity from sumo posturing. I mean, people, I do not know whether you're familiar with sumo or whether you find something of interest, but in sumo, there is fairly little action. There's quite a bit of time being dedicated to that posturing, so where each party effectively shows the strength, but there's no contact, there's no real sort of exchange. So all the communication is non-verbal, non-written. And this sort of posturing is quite a classical feature, if you wish, of cooling off periods. Not much happens until there's and that is a period in which parties can sort of get together internally and try to see how the dispute will be developed. And therefore, what is most important in converting, and I'm using inverted commas, the word converting a contractual dispute into an investment dispute, are the so-called umbrella clauses. So umbrella clauses are provisions in a treaty which provide that the contracting parties undertake to observe any obligations which they have entered into with regard to investment. So the example from the Energy Charter Treaty is that each contracting party shall observe any obligation it has entered into with an investor or an investment of an investor of any other contracting party. And that provides a jurisdictional umbrella so that parties can bring, when there is also a treaty claim, they can bring treaty and contract claims in the same form. It doesn't convert the contractual claim into an investment claim, and the contractual claim will be still governed by domestic law. And it's very interesting that some statistics I have done a few months ago. So the umbrella clause is invoked more or less has been invoked in 156 published ISDS cases. And breach was only found in 19 of them. So the success rate is at 12.2%. So not a very high level of success because tribunals are very careful about establishing the jurisdiction. But historically, umbrella clauses existed so that they could provide for an international depoliticized dispute settlement procedure for all types of contracts and concessions, and does not automatically convert a contract breach into a treaty breach without something more, which is effectively the ability to rely on a BIT. Of course, there's a bit of an issue that sometimes the contractual claim is part of a contract which has a different form selection clause. And one, we have to see whether that clause is drafted in a way so that excludes the application of the BIT and the umbrella clause in the treaty. And also, we have to be able to establish that the actual matter can be attributed to the state, and therefore it does make sense to bring the case to the state. So it has to be a contract with a company which has a monopoly position, or a company which has a special status, or whether the government has an influence upon the management. So what we know, for example, for a couple of cases, I'll just give you two very brief citations here. From the Vivendi annulment, the first Vivendi annulment, a state may breach the treaty without breaching a contract, and vice versa. And this is certainly true of these provisions of the BIT. So provisions of the BIT would work, and it's an annulment committee chaired by the late James Crawford, and therefore very high-powered public international position. But keep that in mind for future reference. And in the sort of saga of the SGS cases, there's an SGS in Philippines and SGS in Pakistan case. In the SGS in Philippines tribunal, we see that Article 10, which is the umbrella clause, makes it a breach of the BIT for the host state to fail to observe binding commitments, including contractual commitments, which it has assumed with regard to specific investment. But it does not convert the issue of the extent or content of such obligations into an issue of international law. Therefore, treaty claims subject to different matters, subject to the contract and subject to domestic law to which that matter has been subjected. So what is then why we have an increased use of contractual disputes brought in investment arbitration? What is wrong with state actions and why dispute prevention doesn't work, or how can we make dispute prevention to work? I think, as in every interaction, human, commercial or otherwise, communication is critical. Very often, when investors get disillusioned, there's automatically a breakdown of communications. And when governments suspect that a particular contractual partner is not very happy, they sort of distance themselves. So there is a natural defense mechanism, so that communication is not present. What we have seen is that also that the trigger for disputes is a number of state actions, which are either the result of an abrupt change of circumstances, for example, a political sort of crisis, or a coup, or any action of that matter. For example, the so-called Arab Spring, which was particularly prevalent in parts of Northern Africa and the Middle East, particularly Egypt and Tunisia, Algeria, has generated a lot of cases because emergency measures were taken by the state, and these emergency measures have had an adverse impact, particularly on foreign parties. But sometimes state action is an administrative measure, which is merely a matter of calculated risk. If I'm going to be cynical, the change of regime in the Spanish renewable cases, where Spain took the view that they cannot honor the feed-in tariffs that they have promised to renewable energy investors, it was better for them to go through the investment cases than to honor these reasonably high tariffs. There was a change of circumstances, a commercial change of circumstances. And it seems that that has been the reason there. But we have seen that some jurisdictions, for example, Korea in Asia, Panama in Central Latin America, have specially designated state agencies that can assess the risk of disputes. So they have a number of dispute prevention mechanisms. And on that particular topic, there was a few years back a short report produced by UNCTAD, which has been referred to already today, the United Nations Conference on Trade and Development. And we have seen through the various sort of reforms, we now have provisions of investment facilitation. And that is also sort of works very closely with the concept of dispute prevention and dispute avoidance. Now, dispute prevention and dispute avoidance is a matter of good governance. No business and no state is keen to be involved in disputes. Disputes are traumatic, they cost a lot, they engage quite a number of resources. So any settlement that can happen either in the cooling off period or in any other process of dispute avoidance or dispute prevention would be particularly critical. And of course, this is also the reason why in the last 10, 15 years, we've seen increased discussion about investor-state mediation. Mediation has not had a significant uptake. We have on the record, as already indicated, about 1,200 ISDS cases, but only 13, a very, very, very small number, conciliation cases. ICSID uses the rather old-fashioned sort of public international term of conciliation. So we've seen movement to encourage the states to use mediation more, and also to develop capacity through sort of training and other ways to have more mediation. Of course, from the state perspective, mediation is a bit critical, because if the outcome of the mediation is paying a significant amount of money to an investor, the internal sort of accountability matters are very problematic. And it might have the consequence that certain officials that are prepared to sign the dotted line might have to sort of resign or be subject to intense scrutiny. So moving forward, there's no doubt that state sovereignty is an important principle, and that enables the states to take measures that they think are appropriate for the appropriate running of the state. However, the exercise of sovereignty, a classical exercise of sovereignty, is expropriation, not nationalizing natural resources. So often the consequence of exercise of sovereignty is risk. And one of this risk is disputes, investment or contractual disputes. I think it's critical for states to operate in a business-friendly regulatory environment. If that environment is prevalent, then there will be an appropriate channel of communication. So if a dispute is looming, a lot can be done before it has escalated and before it becomes a full dispute. Of course, in that respect, transparency, accountability, good governance will be very, very significant. In this respect, settlement by mediation or otherwise is not a matter of weakness. Often people argue that Asia is sort of people don't want to lose face, don't want to have disputes. And this is very often what people describe about China, sort of this blend of arbitration and mediation. However, if one looks at Japan, the Japanese view is that once there's been a claim, there's war. So in the war, you don't show any sign of weakness. I'm not entirely sure where exactly Vietnam stands, but certainly a settlement is not a matter of weakness, but it's a way of moving forward. So given that the investment disputes are inevitable, I think I have highlighted in the little time that have been allocated, there's a lot of different avenues where actual contractual disputes could be converted to investment disputes. And it's important for both states and investors to be aware of them and be prepared. And certainly it's also useful not to escalate matters, but to try to keep them resolved as early as possible and as inexpensively as possible. Thank you.
Yeah. Thank you very much, Professor MISTELIS. From your sharings, we understand that it is possible for a commercial dispute to escalate into investment treaty claims. And in fact, the increase in international investment flows are likely to lead to more occasions for disputes, especially investor-state disputes involving an alleged violation of a treaty provision. So now, following Professor MISTELIS' presentation on international practice, could Mr. Minh please share an overview of the ISDS in Vietnam?
Okay, thank you very much, Chang. Yep. So when we talk about ISDS, we always talk about international law. And on that front, I would like to give us some of the statistics first. Vietnam at the moment, I think, is a party to around like 80 international investment agreements. And these are inclusive bilateral investment treaties and also free trade agreements. And you will see a very diverse forms of ISDS clauses or mechanisms in those treaties, in those agreements. You see mediations, intermediary resolutions at the administrative authorities, litigations at local courts, or international arbitrations. And among those 80 international treaties, there are like 48 effective BITs and 5 effective multilateral investment treaties in which ISDS arbitrations is provided for. So in terms of international treaties, it should be noted that Vietnam is not a member of the Exit Conventions. And so disputes involving Vietnamese party may be resolved by exit arbitrations, but with a conditions that it can only be through the exit additional facility. And you have to look at very carefully at the treaties to see if that is applicable to you. And in terms of the domestic legal framework, you can see some provisions or some legal framework in relation to ISDS in the investment laws of Vietnam. And at the moment, you can see that there are 2 significant laws governing investment activities within Vietnam. They are the 2020 law on investment and the 2020 law on public-private partnerships. The laws all recognize arbitrations as well as other forms of IDRs methods for investment dispute settlement, like in Article 14 of the 2020 law on investment and Article 97 of the 2020 PPP law. And besides those laws, you can also see a number of directives issued by the government to enhance the effectiveness and competence of the process of investment dispute management. And those directives are issued with a view of dispute preventions and de-escalations, and also with a view to enhance the capabilities of local government authorities in the management of disputes. And this can be seen as a promising sign in terms of the Vietnamese approach to ISDS, that is not to resolve the disputes, but to prevent the dispute from happening, from occurring in the first place. So in terms of the ISDS cases that Vietnam have been a party to And until now, I think the numbers are quite low. It's only around 8 cases. And out of those 8 cases, only 4 have come to the award stage. And Vietnam actually is quite successful in that respect because Vietnam managed to obtain favorable awards in like 3 out of 4 cases. So that is my overview about the Vietnamese environment in terms of ISDS at the moment.
Yes, thank you, Mr. Minh. Now, from the speech of Professor MISTELIS, we understand that how the contractual claims could be converted to investment claims. However, what are the frequent causes of investor state claims, and in which industry or which sectors investor state dispute frequently arise? Maybe Professor MISTELIS could clarify this question, and then Mr. Dominic can add some more about this.
I think there hardly any sector of the economy which doesn't have investment disputes. I mean, naturally, extracting industries, energy, mining are significant, but we have a lot of disputes in construction sector. And again, a lot of these disputes start effectively as contraction disputes and convert themselves to investment disputes. But then we also have disputes in financial services, increasingly perhaps so, and even in sort of the telecoms, media, we have had quite a number of cases in that respect. So I think there are hardly any disputes where we don't have them. One area perhaps where we have not had investment disputes yet is in the maritime sector. For example, a lot of the discussion that takes place in various parts of the world about green shipping could be seen as a limitation to the capacity of shipping companies to operate in territories and might trigger disputes.
If I could just add a couple of observations of my own. It seems to me that investment disputes happen in trends. There will be a wave of claims of one kind, and then there'll be a new kind of claim. So maybe 20 years ago, we saw all the Argentine peso claims come through. Then in the maybe about 5 years ago, we saw the Spanish claims come through in relation to the tariff reforms. Having had a quick look at recently filed claims, it is interesting how oil and gas disputes seem to be very, very prevalent in the investment dispute space. I mean, by way of example, there was a claim filed only 6 days ago with ICSID, Discovery Global against Slovakia. And just before that, Petronas brought its claims against Sudan for a major oil and gas problem there. Again, mining seems to be quite prevalent again at the moment. Sever Group against France for a $4.5 billion claim. And then picking up on one of Professor MISTELIS's points about financial services, there was a wave of claims against Korea led by Elliott in the financial services space. Recently, we're now seeing claims against Chile for pension reforms. ON Global, Zurich, and MetLife have all brought claims against Chile recently. And then tariff reforms, I mentioned just now about Spain. We've seen a few claims against Italy, but perhaps a little bit closer to home in Vietnam, there are the claims that Japan is afraid of from its own regulation of the renewables energy market, and which saw a claim brought maybe about 6 months ago, the first claim, and they're very worried about more. What I haven't seen is a COVID-related claim yet, and it will be interesting to see if there is a claim brought for COVID regulations or legislation. I have two on my books in terms of material adverse change in the commercial space, but I've yet to see one being brought at the moment under an ISDS provision.
Yeah, thank you. So I also understand that before an investment claims could become an official investment arbitration, we always have a pre-arbitration stage where the investor and the host state could resolve their dispute or disagreements by administrative proceedings or diplomatic channel or mediation, conciliation, etc. So what are the most common steps that the investors take when an investment claim arises? And from your opinion, which one is the most preferable measure? I think that these questions could be answered by all of our panelists because it's expressed your personal view as well on this matter. So, Dominic, do you want to answer this first?
Well, I think that the first thing that any investor should do is to read the treaty or the contract or the investment law. Because if you don't do that, you can make a mistake which could be fatal to your claim. So that's the first thing. In my personal experience, whether or not a treaty or an investment law or anything else requires a notice, on a major claim, particularly against the government, I would always recommend a letter and possibly a notice, even if the treaty doesn't require that, simply to warn the government, look, this is coming and we need to talk. I think it's a very good way of trying to calm things down or cool things off. And I've had some success in the past simply by sending a very formal looking letter, not necessarily on the headed paper of my firm, which tells the government that there is a claim which is brewing and that it needs to be taken seriously, but the investor is available to discuss. And that may lead to consultations, or in one case that I'm looking at, absolutely nothing. And because that has that particular treaty has a notice provision, we're just having to wait and offering discussions. One other thing I would mention is, particularly in older treaties, but I think it's still good law now, one has to be careful of fork in the road provisions. And that goes back to my point about reading the treaty, and in particular, taking a step which you may regret later. Do you want unsatral or ixid, or do you want something else? I think those are the main points that I would raise now, but I'm happy to talk about alternative dispute resolution mechanisms once we've heard from the other panelists.
Yes, thank you. And maybe Professor MISTELIS, you can share something from the perspective of an arbitrator or mediator.
I think first of all, I agree with everything that Dominic said. I mean, if you are likely to consider investment treaty, you do have to start from the text of the treaty. But I think also there are two more things I would like to make. First of all, it really depends on how bad the breakdown of communications are. I mean, if, for example, you have a case of expropriation, or you have, I mean, in some instances, you hear sort of stories where there has been intimidation of the officers of the investor, so they have left the country. So there's not much you can do apart from exercising legal means. I think the other important point is that you need to be thinking as early as you can about the value in your claim, because if you don't have the means because of expropriation and you be considering sort of third-party funding, you will realize that one of the first questions that you will be asked is, have you valued your claim? Have you quantified your claim? How you would quantify it, and what assets you might still have in the jurisdiction, what assets the other side would have. And I think that is one of the questions that has been raised in the chat, which we might address later, which was the security for cost. I think that's a bit further down the line. But that's certainly something that needs to be done, and where, especially where the investor appears to be impecunious for good or bad reason. Now, I would stop here, and then if you've done this sort of your homework, I think trying to establish a channel of communications, either formally or through a mediation or settlement discussion process, or informally, I think is always very useful.
Yes, and Mr. Ming, even though we understand that we do not have a lot of investment dispute related to Vietnamese government, but from your point of view, what are the best mechanisms to settle or to prevent a commercial dispute to escalate into a investment claims?
Yeah, I think Professor Lucas and Dominic have all expressed their views on this, and I agree with them totally. And however, in terms of, if we look at our own backyard in terms of the legal framework, and we may see some very effective measures that can be used to enhance communications, because the theme of this matter, I think, is about communications. And if you look at our own legal system, you may see some of the very effective tools that the government is now trying to promote. So I have mentioned briefly about some of the directives from the Vietnamese government in the earlier part of these sessions. And so some of them maybe you can see that there's Directive 27 of the Prime Minister, and it was issued to improve state management of investment and to prevent emergence of international investment disputes. And also the decisions number 14, 2020, to provide for regulations on coordinations between relevant entities in international investment disputes. So if you look at those directives and instruments as examples, then you can see that there is a shift in terms of the point of view, in terms of the approach of the Vietnamese government to investment dispute. They are trying to be more active, trying to be more cooperative in resolving the disputes before it's actually become something much bigger. And in doing so, the government is trying to enhance the coordinations or the working between the various government entities, and that may be very effective for communications. Because when you have a lot of parties, a lot of stakeholders in the dispute, sometimes the communications may be mistransmitted, or maybe the parties may get different interpretations of the same message, and that may make the dispute escalated, or may make simple things more complicated. So again, I think communication is very important. Yeah.
Yeah, thank you. And the next questions may goes to Professor MISTELIS. In your speech, you mentioned that dispute avoidance and prevention is a matter of good governance. However, it's a record that in most investor state arbitral awards to which Vietnam is the respondent state, Vietnam won most of them, like Mr. Ming said, 3 out of 4. Can we understand that not all of the ISDS claims are grounded or reasonable, and that in some case, the investor used ISDS claim as a tactic to achieve special purpose or to just put more pressure on the hostages?
I think it's fair to say that in all types of disputes, whether in litigation or in arbitration, some claims are tactical, of course, because the objective of the state might not, of the investor might not be to ultimately win the case, but to raise particularly the profile in terms of negotiation strategy for another concession or something like that, and with a lot of alternatives to investment. I think you're right, not just in Vietnam. I think generally the statistics is that the states fare reasonably well in investment claims. I think very often perhaps a decade or 15 years back, when we always have had the bifurcation between jurisdiction and merits, you would have the investors almost invariably winning on jurisdiction and losing very often in the merits. Now we've seen fewer bifurcations. A lot of countries, including my home country, Greece, avoids bifurcation to the extent possible, and have everything done in a reasonably expedited period of the average case, then will be about 3 years. And then if the tribunal is fully informed and looks at the merits and the jurisdiction together, especially when we have issues of admissibility rather than jurisdiction, then often again the state has the feeling that they will fare better, and they do fare better. I think states prevailing not because so many of these claims are frivolous, but because I think a lot of states act rationally. I think I think, for example, you see that a lot of cases say that the investment case is nothing but a risk management exercise for the investor who has suffered an investment risk, a business risk loss, but not an investment risk loss. It was not a political decision of the state that caused the damage. And I think distinguishing what is business risk and what is investment risk, which has an element of political or legal risk, is something that investors do not often do, or perhaps even the legal advisors do not always give them the credit that they need for.
Yes, thank you. Given the time, maybe we should move to the Q&A section. But before we move to the Q&A session, I still would love to hear from DOMINIC about the third-party funding, because contrary to the expectation, it turned out that costs involved in investor-state arbitration have skyrocketed in recent years. As a result, third-party funding appears to be become popular in investment arbitration. So how to find a third-party funder, and in your view, whether the existence and identity of the third-party funder should be disclosed to ISDS arbitrators to avoid conflicts of interest between the arbitral tribunal and the parties, and if the cost of a party were funded by the third party and the investor, for example, wins the case, whether such costs could be recoverable from the other parties, particularly considering that the winning parties has not incurred these costs themselves, but actually is what funded by the third party.
Those are very difficult questions to answer in a very short space of time, I'm sorry to say. Let me answer the easy one first. How does one find funding? Well, actually, in my experience, sometimes funders come and find you. And if you have, funders are always looking for opportunities to finance big cases where they think that there will be an award of damages. Sometimes this can play into the fear that investment arbitration is being used tactically to hold states to ransom. And I'm aware of, I mean, I for one have been approached on 1, 2, 3 different matters by funders looking to book build essentially mass claims against particular states. So funders are out there, funders are hungry, and funders will fund a case, but one with merits. They're not going to throw good money after bad. Alternatively, there are plenty of funders out there, and if anyone in the audience is looking for funding, I'd be very happy to help them to or put them in touch with a funder or with a broker to enable them to get the best deal. Then we get into the I suppose, the policy questions, should funding be allowed? Well, I believe in access to justice. The reason why a lot of the cases that I deal with are disputes is because there are two sides to the story. The investor has his or her tale to tell. The state has its tale to tell as to what has gone wrong and why. And sometimes those disputes cannot really be resolved even with notices or mediation or conciliation or anything of that kind. And an arbitration is required. Now, I don't think it is right that an investor who has lost his or her entire investment in a state on an investment that has gone bad should be precluded by want of funds to bring an investment claim. And if there is a funder willing to fund that claim, then I would be supportive of that, subject to certain safeguards. And the first safeguard, I think, is transparency. And I have every how can I put this? I think it is right that if a claim is funded or even part funded, that should be disclosed. I think that is very much the way the world is going. One has the new ICC rules. I appreciate that's really more commercial arbitration, but you look at the stance taken in the UNCITRAL working group and also the ICSID rules amendments proposals. And it's worth also mentioning what is already in the SIAC rules and their investment arbitration rules. And for what it's worth, the Canada-Europe ETA Article 8.26. Now, what happens if there is an award made against an insolvent or impecunious investor? Well, that could be hard luck for the state. I think if you are a funder, you should not be allowed to fund something but at no cost. Certainly under general English principles, a funder would be or could be liable for funding. And I see no reason why, if a funder is willing to fund an investor, they should not be encouraged to put up security for costs, so that everyone is on a level playing field. There is access to justice, but if it is a bad claim that is dismissed, the state should not be out of pocket for defending the claims.
Yes.
So, sorry to interrupt, Cha. Some audience in Hanoi reported that there seems heavy raining in Hanoi now, so a little bit difficult for them to listen your voice. Would all the panelists please adjust your mic loudly, please?
I'm very sorry.
Yeah, can you please speak more slowly?
Would you like me to repeat the answer?
No.
No, I think that we can move to the Q&A section, and during the Q&A section, we could speak louder, because actually I read from the news that the internet cap in Vietnam has the problem, and that's why the internet may be interrupted from our audience end. But from my place, I see that it's still good. We have good signal here. Okay, so thank you, Dominic, for very detailed and interesting answer for my questions. And now we receive a number of questions from our audience. And we would like to move to the Q&A section with from one partner from Lexcom, one of the largest law firm in Vietnam. The questions go for Dominic. Why investment treaty claims for oil and gas sector are prevalent? Is it because the respondent would typically be a state-owned national oil company, which is a party to an oil and gas concession or production sharing contracts?
It may be, but what I would say is I think it goes further than that. And one has to remember that oil and gas, natural resources are typically under the permanent sovereignty of the state. And when things go wrong in an oil and gas contract, it will often be the state which is taking measures, sometimes to take back its resources, sometimes to regulate the contract, sometimes to shut down production. I've had that one before, etc. So fundamentally, the state is the counterparty to the commercial contract, the PSC, or the concession agreement, or whatever it may be, and it is also the sovereign over the resources, and is also the regulator as well as the legislator under the relevant oil and gas or petroleum law, which I think is the case in Vietnam.
Yes. And the next question actually comes from an official of Ministry of Justice, and is related to the rules of evidence in arbitration. It means that it's not as strict as though applied in the litigation at courts, at Vietnamese courts. So subsequently in arbitration, there may be a situation that evidence provided to the tribunal are reproduced or falsified. We may not say it quite frequent in international arbitration, but in Vietnam, sometimes we receive the claims from respondents that the documents are falsified. And do you think that the rules of evidence in arbitration should be more strict to prevent falsification?
I think, in my experience, Professor MISTELIS is a far more experienced arbitrator than I am, but certainly when I have sat as an arbitrator and when I have been involved in cases where one might suspect the other party of fraud, it's pretty obvious. And I don't think you need to make the rules any stricter. At the end of the day, arbitral tribunals will always want the best evidence. And counsel, if they are reputable, will not want to put forward fraudulent or falsified evidence because they want to preserve their own reputation and to advance their client's case before the tribunal. So I don't think that there is any real need to strengthen rules of evidence in arbitration, not least because if you were to procure an award by fraud, which is what falsified evidence is, you end up with challenges, set-aside applications, and a general lack of enforceability. Maybe Professor MISTELIS has more to add.
Yeah. I have two good reactions to this question, which I think is a very good question. I think the very first English Arbitration Act back in 1696 was introduced for the very simple reason that the rules of evidence were a bit too strict. So investment arbitration follows commercial arbitration in having a bit of perhaps less technical, less strict rules of evidence. But that doesn't mean that the evidentiary burden is lighter in arbitration, quite to the contrary. And I think given that we have the IBA rules of taking of evidence, which have developed over the years, I have quite a bit of practice. We've even seen a bit of a cross-fertilization. For example, the recent Brazilian reform of the rules of civil procedure looked at arbitration in modernizing the rules of evidence rather than other codes of civil procedure. So I agree. I think our tribunals are very aware of practice. I think in commercial and investment arbitration, people talk about the importance of witness evidence, how it can be influenced by biases and short-term memory. I think there's a genuine interest in the community to make sure that the evidence rules are applied correctly. And personally, I don't have much concern in this area.
I think if I may add one more point. There was a very famous ICJ case, Qatar against Bahrain, 20 years ago, where I won't say which party, but anyone interested can go and look at the case and see what happened. But there are rules in the ICJ, but they're pretty light by comparison with national litigation. And there, one of the state's parties falsified evidence, including a map, and I think it was a stamp on a document. And the fallout from that was enormous. They lost the case, and their reputation was really, really rubbished. And I think that the council, even 20 years later, are still embarrassed by that. Now, there were no formal requirements not to falsify evidence, but certainly if a client came to me and said, I've got a dodgy map, or I've got a document that I've hammed up, can we use this? My answer would be no, for the simple reason that anyone looking at the case reports of Qatar against Bahrain, I think would be ashamed to have been involved in that.
Yes, actually, I totally agree with it, because maybe this question comes from the Vietnamese practice that we do not often use the IBA rules on taking evidence. And we do not have any rules on taking evidence actually in Vietnam. So the arbitral tribunal often maybe rely on themselves or only refer to the rules of the courts, the rules of taking evidence of the courts. And therefore, this may be a concern from some Vietnamese party that the documents could be falsified to some reasons. But from your answers, I understand that we could resolve it, or it is not really a matter in international arbitration. Yes, for the next questions is related to, like we discussed about third-party funding for investor, but how about when the state win the case and the investor has to pay to the state? It is said that those awards could not be enforced for the reason that the claimant, which is the investor, don't have any money to pay the amount awarded by the tribunal. Then, and the request for security for costs are not always successful to be accepted by the tribunal as well. So from your point of view, like from your perspective as an arbitrator, or from the perspective as a counsel, could you please share your personal experience, or do you think any solution to resolve this issue?
My experiences as a counsel is limited, but I have encountered applications for security for costs by states, and the tribunal's typical reaction is if the investor is capable of paying the fees of the arbitration, and in some cases actually even the fees for the state, because the state doesn't want to participate in the cost of the arbitration, but participate in the arbitration. Then in such cases, the tribunal will almost never grant the security for costs that will cover the amount disputed. And especially when the state has not formulated a counterclaim, but simply seeks security for costs to cover its legal defense. Whether that's right or wrong, that's a different question. But I think tribunals try to strike a balance, and if they think that the investor towards the actual process provides the fees that need to provide, the advances that need to be provided, as I say, sometimes from both sides, they will stop there. Now, that is why I'm saying that as a matter of dispute avoidance or dispute prevention is important, because a claimant would be looking at assets of the respondent party before they bring a claim. And if there's no assets and the judges just want to have an award which can be recognized but not enforced, that's a risk they assume, because they obviously assume that money will come forward. But But I think states perhaps should engage in the same exercise as well, and see what is the best tactic in defending a case, and how would one defend the case. Look, for example, at the Philip Morris in Australia case. Australia did prevail, but the fees of Australia was 37 million Australian dollars. Could this case have been resolved quicker or less expensive? Possibly. I'm not saying that it would, but that's a ways of trying to get to where you need to get without exhausting a process, another process.
I think if I could just add one practical point based on essentially sad wisdom. You never get all your costs back in arbitration or litigation. In 30 years, I've never managed to recover everything that has been spent by my client or by the client on the other side, whether state, investor, or anybody else. And part of the risk of going into an arbitration of this kind is that you're going to spend more than you recover. And your damages, awarded damages, are likely to be less than you hope to recover. So there is, unfortunately, a calculation to be made. Not only can I afford this, and can I afford to lose it, but can I afford to win it? Because there is a question to be asked there. You know, if I don't get all my costs and I don't get full damages, is it then really worth it? And what are the other costs to me in terms of my investment in that country and my reputation more widely as an, you know, some might say an aggressive investor willing to resort to investor-state arbitration. And I think that feeds through to security for costs, because never once have I been awarded the amount of costs that I've asked for in security. Tribunals just think that lawyers are expensive, and they don't want equally to be seen to be favouring a party applying for security by giving him or her the full measure requested.
Yes, the next question is, what is the role given to the institutional arbitration, or do states give preference to ad hoc arbitration? If this is the case, then why? I think that this question is related to in the investment arbitration, whether we often goes to ad hoc arbitration or international arbitration, and why?
I think in our book, we were saying that ad hoc arbitration is particularly suited for state parties. We do say that. And this is because states in the ad hoc arbitration have more power in designing the process, and they have also more control of confidentiality or transparency. Now, the way investment arbitration has developed, I mean, every dispute which is in ICSID is in the public domain. The existence of the dispute at the very least. So now, ad hoc arbitration, having said that, ad hoc arbitration tends to be more expensive than institutional arbitration. And certainly ICSID is much, much cheaper than ad hoc ancillary arbitration, because the fees of the arbitrators are capped and the fees of the institution are, or the daily fees for the arbitrators are capped. Not the fees, but the daily fees are capped, and the same is sort of for the institution. I think that the Stockholm Chamber of Commerce and ICC, to some extent, have the Permanent Court of Arbitration have quite a role in administering cases, either under their rules, under arbitral rules. And I think if you are not confident about how well the communication would be with the parties, between the parties, then certainly ad hoc institutional arbitration gives that sense of comfort, a cushion, that if things go particularly wrong. But if the parties want to work together, for example, if you look at very substantial cases, gas pricing cases involving states, are almost always ad hoc because they're so high value that going to the institution will be simply too expensive, and arbitral or ad hoc systems will be much more what the parties would like to have.
Yes, very interesting, because when we were in Vietnam, our teachers often say that actually ad hoc is cheaper than is international. When we resolve our dispute in international institution, arbitration institution, because when we go to institution arbitration, we have to pay for administrative fees as well. But if we go to ad hoc, we don't need to pay for that. But it's very interesting that for investment arbitration, ad hoc is cheaper than institution arbitration. And also, I think that this question was raised because ad hoc arbitration is not popular in Vietnam. We only have one ad hoc arbitration since 2010, when the law on commercial arbitration came into force, and therefore a lot of Vietnamese attendants or participants are not familiar with ad hoc arbitration.
But of course, ad hoc arbitration requires that the parties are reasonably experienced, and also that they are on speaking terms. If either of these conditions is not there, then obviously ad hoc arbitration is not appropriate.
Yeah. Okay, the last questions, I think that is still related to the third-party funders. One of our attendants asked that, is there any ISDS funder in Vietnam? Well, I have not aware any ISDS funder in Vietnam, but I trust that from somewhere around the world, we will have the third-party funder who willing to fund for ISDS in Vietnam, right?
Absolutely.
Dominic, you want to answer this question?
And there are funders I know in Singapore who would be more than happy to speak with you. I mean, if you would like an introduction, please send me an email, and I'd be very happy to put you in touch with people, whether a funder directly or a broker. It's very much up to you.
Yeah. So I think that we go through all of the questions raised by our audience, and thus it leads to the end of this topic. So for more than 1 month, we have discussed 7 topics related to international arbitration strategy and practical tips. And now we come to the last section. I would like to invite Mr. Emanuel, our senior partners, to have a closing remark to our webinar series.
Thank you, Chang. But before closing the webinar, I still have the last question to Professor LOUKAS, because I know that many of my colleagues as a participant of this webinar, and they really need to study, self-study themselves on the arbitration, especially on investment arbitration. So would you, Professor LOUKAS, on your teaching experience, would you please give them some guidance on how to start studying on investment arbitration? Thank you, Professor.
Yeah, I think now there are a number of programs, and there is also quite, I mean, a study as a matter of an academic degree gives you a depth that you will not acquire in a seminar, but there are plenty of very, very good seminars if one doesn't have the resources or the time to do a full-fledged LLM. I think Quinn at the moment offers 5 investment arbitration subjects, not 1, but 5. So for policy, substantive protection, but of course there are other providers, as the BBC would say, are available in all parts of the world. But start by joining, but I think ICSID on their website has a number of very good short videos that could give you a bit of an indication. And UNCTAD has a course on dispute settlement, which you can do by way of self-study, and gives you quite a bit of a very good foundation. It's called UNCTAD course on dispute settlement. Some of it is a bit dated, but it's very good quality. And of course, and US in your neighborhood, Hong Kong, university, but also sort of places like Queen Mary, Geneva, Stockholm, NYU, Columbia have very good programs as well.
Thank you, Professor. Thank you, Professor. The other question comes from my colleagues, which I think that Dominic maybe is the right person to answer. Is they said that it seems that the ISDS case only come to the big firm. So small firm like local firm in Vietnam has no chance to be involved in such kind of the claim. What do you think about that?
I disagree. I disagree. I think that the best combination, and one where I've worked very successfully in the past, is to team up a local firm, because very often you will need advice of local law, constitutional law, investment law, maybe petroleum law, but there are lots of things where you need local advice. So a good local firm or a national firm with a good international firm, not least because I think that sends a really serious message to the state that this is a claim which is being taken very seriously, needs to be taken very seriously. We have local experts, we have international experts, and we intend to win. And in my experience, the best way to win peace is to prepare for war. And if you signal that to your opponent, I think you will have a much better experience of a major arbitration of this kind than going for a firm which has no experience either of the local law or indeed of the investment law.
Thank you, Professor LOUKAS, MISTELIS, and Mr. Dominic ROUGHTON, Mr. Ming and Chang for your insightful and thought-provoking discussion. It's been a pleasure being with all of you today. I'm very honored and delighted to deliver the closing remark on the last day of the 2021 webinar series of Sung ST Associate on International Arbitration. First of all, I would like to thank all the wonderful speaker panelists who joined us and spoke throughout the last 7 weeks. All of you taking time out of your busy personal and professional schedule mean a lot to us. Throughout the series, we touched upon the most challenging and often seen issue in international arbitration, focusing on the political solution to overcome them. Procedure or the Gruner tactic from the opponent, difficulty in taking and presenting the evidence and enforcement of arbitration awards. Sector as we discussed construction, energy, arbitration. Finally, in the today webinar, we discussed the investor debt arbitration option. Whatever matter throughout the series, efficient and ambitious resolution of dispute always the end purpose of arbitration. I feel, along with many others, that this webinar series is very useful and should continue annually. Someone asked me. Thank you again for speaker and for valuation contribution. I also sincerely express my thanks to our supporting organization, including Vietnam National Arbitration Center. VIC is the most active local arbitration institution in Vietnam, and all the law firm of the speaker who contribute to the successful webinar series. More importantly, I would like to thank you all, the participants. Without your input, interaction, and questions, this webinar series would not have been a success. I'm very happy that the webinar series have reached out to many people from many different backgrounds. After 7 webinars, we have been joined by over 500 participants from around over 110 law firms, 30 law schools, nearly 100 community in-house counsel, and the participants not only come from Vietnam but from other 30 different jurisdictions. Also an impressive figure in my opinion. This result is a big encouragement for us to design and develop further discussion events in the future. We hope that you have enjoyed the webinar and that information discussed over the past week would be helpful for your practice. Finally, I'd like to send my best wishes to all of you, your family during this pandemic. I truly hope that we soon have a chance to meet and discuss physically in the near future. Until that time, please be safe and healthy. Thank you very much. Thank you, Professor LOUKAS. Thank you, Mr. Dominic Carlton. And thank you all the participants. We will send you the slide and material kindly provided by Professor LOUKAS MISTELIS at the end of the webinar. And we look forward to meeting you soon in another occasion. Thank you and goodbye.